because, you know, we have decorum at the bar. If you have a professor of law misbehaving at the bar, then I'm urging that you direct that remark to be withdrawn first, then we make progress. I'm urging, my lord. The remark was made in your presence. I'm urging it to be withdrawn first, then I can respond.
My lord, I have no problem with withdrawing the remark. But the point is, it is a veiled application for adjournment. Because Mr. Ogoya is saying that the court must address the question of empanelment before the recusal. So why can't you just get to the point?
I'm answering the question now, but I know that he has withdrawn. He said he has no problem withdrawing, but he didn't withdraw. I want him to withdraw first, my lord, because I'm entitled to dignity.
I have no problem withdrawing. No, I have no problem, my lord. I withdraw the remark.
Thank you so much. Thank you.
There is practice.
Thank you. Let me now address the question as a test.
All applications and procedural decisions. You can make a submission to this court and consider.
My lord, if I may, just to guide the court on this account, I will do it as soon as possible. My lord, the urgent application is for you. The applicants or the petition has applied yesterday on a preliminary objection to the application that was filed for you dated 18th October 2024 for discharge of whatever decision this court makes can be either way. We need two directions on the hearing of all the consolidated petitions. Some of the petitions deal with issues or go to the version that were before the Lord's impeachment. The proper position of the law is that the party who is the petitioner is the former deputy president. That's the position of Article 145(7). Allow us, my lords, to urge our application for the setting aside of conservative orders. I think, my lord, that's the only way we can move, because the about the right, let us have our rights as well. We will only take 30 minutes, we request.
I'm not disagreeing with you, Professor Ojienda. What I'm saying is that let's mention these files.
Yes.
We are on the third one. And if you have been interrupting, perhaps we will see them. 5550. Yes. What I asked, is this file related to the files before the court? For the purposes of consolidation, or it can stand alone.
Can we deal with that tomorrow? My lord, tomorrow.
By setting out, your ladyship, the documents that we have filed for the record, we have filed submissions.
Incidentally, Professor, we have the ball.
Yes.
We also risk them.
Yes, it's okay, your ladyship.
We also go through that task of listing them before the hearing.
Yes.
So if you can save your time.
Yes, I will go right to the questions, your ladyship. Your
With your
ladyship.
kind permission, my lady, with your kind permission, it seems that amply Professor has left out my name.
Sorry, Mr. Ian Wambua, sorry. Your ladyship, I wanted to just deal with that Mr. Ian Wambua Mbithi is holding brief for Mr. Mugeni, Senior Counsel, who is involved in other Senate business and therefore will not be here. So just
so
for,
this
yes,
is Ian.
Wambua Mbithi.
Thank you very much. So you have the 30 minutes.
Yes.
Starting now.
Yes, your ladyship, this appeal originated from the High Court, and the initial High Court petition, your ladyship, was Constitutional Petition number 284 of 2019, which dealt with, amongst others, your ladyship, the interpretation of the powers of the Speakers of Parliament under Article 110, Sub-Article 3 of the Constitution, read together, your ladyship, with the powers of the National Assembly under Article 95 and the powers of Senate under Article 96. All must be read together. Your ladyship, this commenced as a constitutional question, and I'm submitting this, your ladyship, so that the question of jurisdiction peradventure would be a matter that I need not argue before this court. I therefore will not need to cite Lawrence Dutu and that other long line of cases on jurisdiction, because this court has jurisdiction to entertain this appeal under Article 163 3A. Your Ladyship, the initial successful petition at the High Court led to the declaration of unconstitutionality of 24 statutes enacted by the National Assembly without following the mandatory requirement of a meeting of the speakers on the bills. Article 110, Sub-Article 3, Your Ladyship, provides that before any bill is brought to the House, the speakers of the National Assembly and the Senate shall jointly resolve any question as to whether it is a bill concerning counties. And if it is, Your Ladyship, whether it is a special or an ordinary bill. The contention and what has led us to where we are was that these 24 bills that led to the initial cause of action did not go through the mandatory requirement of Article 110, Sub-Article 3. We will argue, Your Ladyship, that not only did the Speaker of the National Assembly ignore the provision of the Constitution, but the Speaker of the National Assembly, Your Ladyship, also ignored the decision of this court in Supreme Court Advisory Opinion number 2 of 2013 in the matter of the Speaker of Senate, which was a decision that was available for consultation by the Speaker at the time these 24 bills were processed. In the end, Your Ladyship, our petition prays that the misdirection by the Court of Appeal, Judges Murgor, Judges Pauline Yamwe, and Judges Lesit, that proceeded to apply to set aside the decision of the High Court, be set aside. And in place thereof, Your Ladyship, this court upholds the decision of the High Court. Your Ladyship, in the 12th Parliament, at the time of the filing of the petition of appeal, we submit that it was deliberate on the part of the Speaker of the National Assembly to proceed to consider bills whilst ignoring what Article 110.3 sets out. And we refer the court to Volume 5, Paragraph 443, and Volume 16, pages 2019 to 2017, on that question, Your Ladyship. Your Ladyship, concurrently, we are aware that the Council of Governors also filed another petition that were all consolidated and that have led us to where we are. Your Ladyship, we submit that the Court of Appeal, whilst there was a cross petition, found, and we submit, that any bill which has not been subjected to concurrence envisaged by Article 123, first of all, my Lord, Your Ladyship, must be found to be unconstitutional. Because applying the purposive approach to constitutional interpretation, the people, while crafting the Constitution, intended that Article 110.3 is given primacy and is the very foundation from which all the other articles defining money bills and ordinary. We refer to two decisions. The first decision is Advisory Opinion number 2 of 2013, and we have set out the analysis in our case digest. Your Ladyship, this decision concerned the interpretation of the applicability of Article 110.3 on the Division of Revenue Bill, which action was before the Supreme Court. Your Lordship, the court was emphatic in this matter, and I want to refer to paragraph 141, where the court was emphatic that it is quite clear, though some of the counsel appearing before us may have overlooked this, that the business of considering or passing any bill, and emphasis here, Your Ladyship, is bill, any bill, is not to be embarked upon and concluded before the two chambers acting through their speakers address and find an answer for a certain particular question. And then the court proceeds. What is the nature of the bill in question? The two speakers, in answering that question, must settle three questions. First, before a bill is published, they must go through the motions of debate, passage, and final assent by the President. The questions are, is it a bill concerning the county government? If it is it a special or ordinary bill? Then the court proceeded, Your Ladyship, to find as follows, that if it is not a bill concerning the county government, is it a money bill? It is only after that process that the speakers then, whilst answering these questions, proceed to know where the bill falls and to know where the bill is then placed, whether it is debated in the National Assembly or whether it is debated in the National Assembly and in Senate, if it touches and concerns county governments. It is peradventure, Your Ladyship, that the 24 bills we referred to and that were the subject of the proceedings in the High Court and the Court of Appeal were not or did not meet the test of Article 110, Subarticle 3. Sadly, Your Ladyship, the Court of Appeal, in its misdirection, distinguished erroneously the decision in the matter of Speaker of Senate as a decision applying specifically to the Division of Revenue Bill. For that misdirection only, Your Ladyship, the judgment of the Court of Appeal must be set aside. The Court of Appeal should have read into the classification by the Supreme Court that Article 110, Subarticle 3 apply to all bills and not only to the Division of Revenue Bill. Your Ladyships and my Lords, it is instructive, again, that this decision was made available to the Speaker of the National Assembly. But Your Ladyship, let me go further and confirm that this court has dealt with any legislative concerns touching on Parliament in the matter of the Interim Electoral Commission, Supreme Court reference number 3 of 2019, where the court, whilst dealing with the term Parliament in its legislative duty, underlined, Your Ladyship, that whilst Article 95 and 96 sets out the role of the National Assembly and Senate in their legislative duties, there are several overlaps in these functions. And therefore, the court underlined that legislative duty incorporates both houses where there are several legislative overlaps. And whenever there's a reference to Parliament, then any bill where any reference is made to Parliament in any undertaking, Your Ladyship, for instance, in approvals, then Parliament must mean both houses. The intention originally, Your Ladyship and my Lords, was that the Senate would be the upper house, a house of wise women and men. And I think that has come to pass, they're wise. Your Ladyship, let me submit further that this court has gone further after the filing of this petition. In its decision in petition number 1 of 2018, which is the Institute for Social Accountability and the National Assembly and others, the CDF decision, this court again, whilst declaring the CDF Act 2015 unconstitutional, again went to the same interpretation. At paragraph 71 of the decision of this court, the court found at paragraph 75 that we agree with the reasoning adopted by the High Court that while the concurrence of speakers is significant in terms of satisfying the requirement of Article 110(3) of the Constitution, it does not by itself oust the power of this court vested in Article 165(3)(d), where a question regarding the true nature of legislation in respect of 110(1) is raised. And that was the submission. The mandatory provision still allows the court to evaluate. In this case, Your Ladyship, the court evaluated the intent and import of the CDF Act 2013 and found that the CDF Act covered questions that touched on counties and was enacted without the participation of the